Just looking back over the years of practising at the bar, what do you think has become easier for women at the bar now as compared to when you were starting out? Clearly rooms must be one thing.
Rooms is one thing. I was actually going to answer very simply by saying being there. It is much easier being there. I moved from the 9th floor to the 6th floor, and I still have a connection with the 6th floor, and there's a lot of women on that, and young women, and there's a camaraderie and a camaraderie on that floor, which is fantastic amongst all the barristers. You don't get that, oh, well, she's the female, do we have to invite her along type of thing. There's really just great support and friendliness on the floor. So I think just being there because of numbers is much, much easier.
And can you think of anything that I suppose that may have happened then that you can't imagine? Oh, I beg your pardon. Margaret, were there formal clothing requirements, conventions and expectations for women barristers that were different then to what they are now, to your knowledge?
Look, that is difficult. I mean, I took an attitude. I did get into trouble just slightly once about clothing in the family court because I just thought it was sort of, if I thought something was appropriate for office, it was appropriate for court. But again, there was a very crusty old judge who didn't think that was appropriate, and had to sort of be suited in effect. These days, things have changed. There's very much a suit mentality amongst young professional women. Anyway, you stand on the corner of any street in the city, and you will basically see black and or grey suits, either trouser suits and or skirt suits, and basically a white, maybe a pink open-neck shirt. So there's become a little bit of a uniform for women anyway. I think that's a little uninteresting. I think it's nice to actually be able to dress not so much to a uniform, but I just don't think it's an issue anymore.
What would you say to women now considering a career at the bar?
Go for it. I mean, absolutely. Look, I'm just a great believer in doing what you want to do. Perhaps that's what was that's perhaps one of the great legacies I had from my education with the Josephites. One thing I do say though is, if you don't love it, don't do it. I think the bar is too hard as a profession for anybody if you don't really love it. And so even if for one stage you thought you might have had an inkling for it, if it doesn't work, I think find some other aspect of the law that you really do love.
You've had a wonderful career over a number of years, aside from, of course, being appointed Queen's Counsel in 1989. You were appointed in 1993 a judge of the Federal Court of Australia, and then in 1996 you were the first woman appointed to the New South Wales Court of Appeal. And you've been, among other things, chairperson of the New South Wales chapter of the Australian Institute of Administrative Law. You were made an officer in the Order of Australia and the Queen's Birthday Honours List in 2006 for services to the judiciary and the law. A very satisfying, I'm sure, a career when you look back. In some, though, is there anything you feel you didn't achieve that you would have liked to have achieved, or do you feel on the whole you've pretty well done everything that you'd wanted to do when you first sat out?
I haven't read enough books.
You are a glutton for punishment, are you?
I'm in mad catch-up mode. I am reading. I love reading. I always loved reading as a kid. And I suppose I love two things, reading and talking. And I think undoubtedly, therefore, I've chosen the right profession. And I really do love the law. I love it, intensely. But I love a lot of other things too. And, I love music, I love reading, I love art. And so therefore, one thing that the law does not give you is much leisure time. And it doesn't give anyone much leisure time, and if you've got a family, it gives you no leisure time, except for the kids, which are not leisure, but enjoyment. And but if I'm trying to do anything now, it's madly to read. I have just taken a week off, and I read 2 books. I'm so proud of myself. little bit. One was a novel, the Goodbye to Berlin, the Christopher Isherwood novel, but it's based in an era of history in which I'm very interested. And the other one was Doves of War, which was historical, which was based on the stories of 4 women who worked in Spain during the 2 English women, 2 Spanish women in Spain during the Spanish Revolution. And I went to Spain at Christmas because my 2 daughters were in London at the time, so my son and I met them in Spain for Christmas, and that was terrific. So I've sort of read quite a bit historically around that time, or any novel which has an historical feel about it tends to be where I go.
Just finally, I would like your comments and observations on this. The judiciary has been somewhat under attack in recent years, and Marilyn Warren, the Chief Justice of the Supreme Court of Victoria, recently spoke out about the fact that when judges write their judgments, they're not really in a position to respond quickly to the criticisms they get in the media. And she was saying there may have to be things done like obviously posting judgments on the internet and things. She didn't see any reason why judges should take to blogging and twittering. But do you have confidence, Margaret, that there will be our system of justice, our legal system will continue much as it has, or do you see great changes coming ahead whereby we may see changes in the legal landscape that perhaps we're not even really envisaging now?
Well, the great change that's happening at the moment is to alternate dispute resolution. That's, that really is a very significant direction, and that will have that will make a difference. And I think the type of case that goes through the traditional legal system will be the more difficult case, which requires some principle of law to be worked out, for example. So there's no doubt in that way. I would be totally opposed to twittering and blogging. I think that reduces what is a really very important societal institution to almost a nonsensical reactive institution. And it's got to be much better than that. I have a great belief in the internal integrity of the institution. Unless it's strong within itself and competent within itself and delivering services, which I hate that word, but delivering justice, that is justice according to law, in an efficient manner, then it will fail. It will not achieve anything by twittering, is my opinion. But I think the big changes that we're seeking to implement at the time is to really is now enshrined in Section 56 of our Civil Procedure Act, which is just quick and cheap resolution of proceedings. I said recently in a paper that I gave that I thought that that's not necessarily the best epithet, particularly the cheap aspect of it, because when people talk about cheap, I think they think of Franklin's, and that's not what we're talking about. I think we're really talking about proportional costs, and I think that's a very big, huge issue at the moment, is the lack of proportionality in costs. Interestingly, I was talking when I was in England at Christmas, and I was talking to some of the Supreme Court judges there, and they were just having a review on costs. And I said I found this very difficult to understand how they were going to do it, because I found it difficult to understand how you would ever control commercial costs. And, they said to me at the time, Lady Brenda Hale in particular, she said, we already have a 4-tier legal system in the United Kingdom. That is, and that's basically tiered by costing. And if you want to start at the top, it's obviously the huge legal fees charged in the commercial matters by the silks, and it goes down really to the probably legal aid, public interest type litigation. So I'm not sure that's good. To have that lack of integration within the one system, but it certainly is an accepted reality in England.
Margaret Beazley, thank you very much.
Thank you.